The Department of Justice has released tens of thousands of documents, including photographs, police reports, and evidence logs from the Department of Justice. The Department of Justice has begun unsealing the Epstein files.
The bottom line is it's not anywhere near a full release.
Congressman Ro Khanna helped pass the bill, which required the DOJ to release all unclassified files by Friday night. The documents include thousands of photographs, many redacted. The faces that can be seen include Jeffrey Epstein and Ghislaine Maxwell, plus notable figures like former President Bill Clinton.
I believe there was more than just redacting the victims' names and family members.
The law allows for some redactions about victims or ongoing investigations, but explicitly states information cannot be withheld due to embarrassment, reputational harm, or political sensitivity.
So his attorney general has to comply with it, and there are penalties if she does not.
President Trump continues to distance himself from the investigation.
I have nothing to do with Jeffrey Epstein. It's a hoax. The whole thing is a hoax.
He signed the law after he lobbied against it. Previously subpoenaed photographs Congress released show President Trump with Epstein. And Deputy Attorney General Todd Blanche already warned that the DOJ would not be releasing the full batch of documents on Friday. Congressman Ro Khanna is calling on the DOJ to provide a timeline as to when the rest of those documents will be released. For now in Washington, Raquel Martin.
Congress just passed the law requiring the Justice Department to release Jeffrey Epstein's files by a specific deadline. That deadline has come and gone. The DOJ missed the deadline and has not complied, offering shifting and contradictory explanations instead. And now, lawmakers are openly discussing impeachment of Attorney General Pam Bondi. But here's what most people aren't asking. What does that actually mean? Not whether it's justified. We can all see the deadline was missed. The real question is how this works, what tools Congress actually has, and why they might pursue impeachment even if removal is nearly impossible. Because this isn't just about Pam Bondi. This is about whether statutory mandates mean anything when the executive branch decides to ignore them. Let's decode what's really happening here. The Epstein Files Transparency Act passed with overwhelming bipartisan support. We're talking 427 to 1 in the House. Unanimous consent in the Senate. Donald Trump signed it into law. This wasn't partisan legislation. This was as close to consensus as Congress gets. The law was clear. The Department of Justice had 30 days to release Epstein-related records. Not 30 days to start thinking about it. Not 30 days to begin a review process. 30 days to release the files. December 19th was the deadline. That date has passed. The DOJ has not complied and has offered no concrete timeline for when they might actually follow the law their boss signed. And this is where things get interesting, because Congress wrote a law that the executive branch is simply choosing not to follow. The question becomes, what happens next? Most people think impeachment is the only card Congress can play. That's not true. Congress has 5 distinct enforcement mechanisms when the executive branch ignores statutory mandates. Impeachment is actually the nuclear option, the last resort, not the first move. Let's walk through what's actually available. First, there's inherent contempt of Congress. This is an old power, dating back to the 1790s, though it hasn't been used since the 1930s. Here's how it works. The House votes to hold an official in contempt, and then, and this is the key part, they can impose daily fines without involving anyone else. No Senate vote required. No DOJ cooperation needed. Just the House deciding someone is in contempt and fining them every single day until they comply. Representative Ro Khanna laid this out pretty clearly when he said the House alone can fine Pam Bondi for every day she refuses to release the documents. Think about that. $10,000 a day would be $300,000 a month. That adds up fast. Representative Thomas Massie, a Republican from Kentucky, called this the quickest and most expeditious path to get justice for Epstein's victims. And Massie's involvement here matters enormously because it preempts the partisan witch hunt narrative before it can even start. The advantage of inherent contempt is speed. It's a House-only vote, which means Democrats would need just a handful of Republicans to join them. Given that the underlying law passed 427 to 1, that threshold seems achievable. The disadvantage is that it's rarely used and legally untested in modern contexts. Bondi could challenge it in court, and we don't know how that would play out. Second option, criminal contempt of Congress. Congress votes to cite someone for criminal contempt, then refers the case to the U.S. Attorney for prosecution. Sounds straightforward, except there's a fatal flaw. The U.S. Attorney works for the Attorney General, who is Pam Bondi. So Congress would be asking Bondi's subordinate to prosecute Bondi. That's not happening. However, Massey raised an interesting point about this. A future Justice Department could prosecute the current Attorney General. Obstruction of Congress has a 5-year statute of limitations. Conduct in 2025 remains prosecutable through 2030. So even if the current DOJ won't act, this creates criminal liability that outlasts this administration. Third, civil lawsuit. Congress could sue the executive branch in federal court to enforce the statute. Get a judge to order compliance. If Bondi defies a court order, that's contempt of court, which carries its own penalties and is harder to ignore than contempt of Congress. Senator Chuck Schumer introduced a resolution directing the Senate to authorize such a lawsuit. Multiple senators requested an inspector general audit as an alternative. The advantage of a lawsuit is that judicial enforcement is independent of the executive branch. The disadvantage is time. Litigation takes months, sometimes years. Appeals delay things further. By the time a final order comes down, the political moment may have passed completely. Fourth, defunding. Congress controls the federal budget. They could withhold Justice Department funding until Bondi complies. This has been done before for other issues. Think about how abortion restrictions get attached to appropriations bills. But there's a problem. Republicans control the House, the Senate, and the presidency. They're not going to defund Trump's Justice Department. Even if such a bill somehow passed, Trump would veto it. And overriding a presidential veto requires a 2/3 supermajority. That's not happening with Republicans in control. Fifth, impeachment. This is the constitutional process for removing federal officials. The House impeaches with a simple majority, like an indictment. Then the Senate holds a trial and votes on conviction and removal. That requires a 2/3 supermajority. Currently, the House has 220 Republicans and 215 Democrats. The Senate has 53 Republicans and 47 Democrats. To impeach, you'd need 218 votes in the House. Democrats have 215, so they'd need at least 3 Republicans. To convict and remove in the Senate, you'd need 67 votes, all 47 Democrats, plus 20 Republicans. That math is brutal. Getting 20 Senate Republicans to vote for removing Trump's Attorney General is essentially impossible under normal circumstances. So why are Khanna and Massey even talking about impeachment? Here's what Khanna and Massey have actually said. They're drafting articles of impeachment as we speak, but they're not going to file them right away. They're waiting to see if the DOJ complies. This is a deliberate escalation ladder. Step 1 was threatening consequences. That's done. Step 2 is drafting the articles. That's happening now. Step 3 would be filing inherent contempt charges, imposing daily fines. Step 4 would be filing the actual impeachment articles if fines fail. The point isn't necessarily to remove Bondi from office. The point is to create maximum pressure at each stage while maintaining flexibility to back off if compliance happens. Think about it from Bondi's perspective. As long as impeachment articles are being drafted but not filed, she faces uncertainty. She doesn't know when or if they'll actually drop. That uncertainty has its own deterrent value. Once articles are filed and the process plays out to acquittal, that leverage is gone. the threat loses its power. Khanna explicitly framed this around survivor advocacy. He's in touch with Epstein survivors and their lawyers. He's talking about bringing survivors back to Capitol Hill to demand compliance. That's not just political theater. That's creating moral authority that's very difficult for Republicans to argue against. And Massey's participation creates a bipartisan shield. Every statement, every interview, it's Massey and Khanna together. Not Democrats versus Republicans, not partisan warfare. Two members from opposite parties saying the same thing. A law was passed. The deadline was missed. Compliance is required. Massey even posted a poll on social media asking whether Bondi should be impeached. 77% of respondents said yes. Now, that's not a scientific poll. Online polls are easily manipulated and don't represent a random sample. But it creates a perception of public mandate. It gives Republicans political cover if they want to take action. The calculation for Republicans becomes, is protecting Trump's Attorney General worth defying a law that passed 427-1? Is it worth siding against Epstein survivors who are demanding transparency? Is it worth ignoring your own constituents if 77% of poll respondents support accountability? Let's say the House does impeach. Let's say it gets through committee, comes to a floor vote, and somehow 218 members vote yes. Then what? The Senate holds a trial. House managers act as prosecutors. Bondi's legal team defends her. Witnesses can testify. And this is where it gets interesting. Epstein survivors could tell their stories under oath on the Senate floor. Documents produced during the investigation would become public record. Everything would be out in the open. Then the Senate votes. 67 votes needed to convict. With 53 Republicans and 47 Democrats, you'd need every Democrat plus 20 Republicans. Historical precedent is not encouraging here. Only 21 federal officials have ever been impeached since 1789. 8 were convicted and removed, all of them judges. 3 presidents were impeached: Andrew Johnson, Bill Clinton, and Donald Trump twice. None were convicted. Only 1 cabinet member has ever been impeached: William Belknap, Secretary of War under President Grant back in 1876. He was accused of taking bribes. He resigned before the impeachment vote, but the House impeached him anyway. The Senate acquitted him. More recently, in 2024, Homeland Security Secretary Alejandro Mayorkas was impeached by the House on a party-line vote. The Senate didn't even hold a full trial. They dismissed it with a procedural vote. That's probably what would happen here if impeachment reached the Senate. So if conviction is nearly impossible, why pursue this at all? Because impeachment accomplishes things beyond removal. It creates a comprehensive evidentiary record. Everything that comes out during the investigation, documents, testimony, timelines, becomes part of the official congressional record. Future prosecutors can use that evidence. Massey explicitly made this point. A future Justice Department could convict the current Attorney General using the record established during impeachment proceedings. It forces public officials to take positions. Every member of Congress has to vote. That vote becomes part of their record. In 2026, when midterm elections happen, voters will know exactly who voted to protect Bondi and who voted for accountability. That's a campaign issue. It gives survivors a platform. Epstein's victims have been fighting for transparency for years. An impeachment proceeding would put them on national television, testifying before Congress, telling their stories. Even if Bondi isn't removed, that validation matters. That recognition matters. It establishes precedent. If Congress lets this slide, if the executive branch can miss a statutory deadline with 0 consequences, what's to stop future administrations from doing the same thing? But if Congress pursues accountability, even unsuccessfully, it sends a message. Violating statutory mandates will trigger serious consequences, even if removal isn't guaranteed. We can already predict how this will be defended. The talking points practically write themselves. This is a partisan witch hunt. Democrats are always trying to impeach Trump officials. First Trump himself, then Mayorkas, now Bondi. Impeachment has lost all meaning. It's just a political weapon. Except this law passed 427 to 1. Trump signed it, and a Republican congressman is co-leading the impeachment effort. That's not partisan warfare. The DOJ is complying. They're working around the clock. They've already released thousands of pages. There are millions of documents to review. The deadline was unrealistic given the volume. Except the deadline was 30 days from the law being signed. Trump agreed to that timeline when he put his signature on the legislation. If it was unrealistic, he shouldn't have signed it. And back in March, Bondi claimed full and complete files had been delivered. In July, the DOJ said their exhaustive review was complete. Then in December, suddenly, there are millions more documents that need reviewing. That's not compliance. That's stalling. Releasing everything immediately would harm victims. The DOJ needs to carefully redact names to protect privacy. Democrats don't care about victims. They just want to embarrass Trump. Except the survivors themselves are demanding release. Kana is in direct contact with survivors and their lawyers, who support enforcement action. And by the way, the DOJ actually violated victim protection. They released files with some victims' names not properly redacted. So, claiming to protect victims while violating the very law designed to protect them is obvious bad faith. This violates separation of powers. Congress can't micromanage how the executive branch operates. The DOJ has legitimate concerns about ongoing investigations and executive privilege. Except this isn't micromanagement. This is enforcing a statute. Congress writes laws, the executive executes them. That's how separation of powers works. Each branch has its power. The executive branch doesn't get to be above the law just because following it is inconvenient. Short term, watch for inherent contempt. That's the most likely first move. House vote to impose daily fines. It requires fewer votes than impeachment, doesn't need Senate cooperation, and creates immediate financial pressure. If Kana and Massey can bring a handful of Republicans on board, which seems plausible given the bipartisan nature of the underlying law, inherent contempt could pass within weeks of Congress returning from recess. If that happens, Bondi faces a choice: pay indefinitely, comply with the statute, or challenge the contempt power in court. Challenging it triggers litigation that could last months while fines pile up. Paying makes her look weak and guilty. Complying means releasing files she clearly doesn't want released. That's the squeeze. If inherent contempt fails or Bondi defies it without consequences, impeachment articles likely get filed, not because removal is likely, but because the escalation ladder demands it. Each step has to follow the previous one to maintain credibility. Longer term, this becomes a 2026 campaign issue. Republicans who voted against accountability face challengers who ask why they protected an attorney general who missed a bipartisan transparency deadline. Democrats run on holding power accountable even when it's difficult. And even longer term, 2029 and beyond, there's the criminal exposure. If Trump leaves office in January 2029, a new attorney general could review the evidence from impeachment proceedings and contempt findings and decide whether to prosecute obstruction of Congress. The statute of limitations runs until 2030 for conduct that occurred in 2025. Even if Bondi escapes immediate consequences, the legal liability doesn't disappear when Trump's presidency ends. Here's what this case really exposes: the gap between constitutional tools and political will to use them. Congress has multiple mechanisms to compel compliance: inherent contempt, civil lawsuits, criminal referrals, impeachment. Every single one exists for exactly this scenario, but whether those tools actually get used depends entirely on whether Republicans will allow consequences for missing a deadline under a law they overwhelmingly supported. This is the real test. Not whether mechanisms exist, but whether they function when needed most. Can Congress actually check executive power when the same party controls both branches? The Mayorkas precedent suggests the answer might be no. House impeached, Senate dismissed. Party loyalty trumped institutional obligation. Congress passed a law requiring transparency. The executive branch missed the legally binding deadline. Now Congress has to decide. Do statutory mandates mean anything? The tools exist. The question is whether Congress will use them, or whether laws only bind the executive branch when politically convenient. Right now, we're watching Congress decide. Will they use the tools they have, or will they let this slide? The answer to that question matters far beyond Pam Bondi and these specific files. It matters for whether laws mean anything at all. Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.